Good morning, everybody. How are you doing? Yeah. For a Saturday morning at 10 o'clock? Okay. So some of you I recognise, some of you I've seen before. I'm Philip Warford, I'm the Managing Director of Renaissance Legal, and I've come along to have a chat to you about how you put in place a protection mechanism. So legal protection to make sure that anyone WS affected is protected in terms of inheritances, decision making, everything around powers of attorney. So I'm going to talk until probably about 20 past, but also I'm doing some Q&A sessions a bit later on. I wanted to make this a tiny bit interactive. We've got limited numbers, so it may mean that I point directly at someone to try and give me an answer, so that will keep you awake. I have been working in the law for 33 years, and 12 years ago I launched Renaissance Legal because I got bored of working in big law firms where I couldn't really make a difference. And it's about doing things like this and outreach and those sort of things. So Renaissance Legal is a specialist solicitors firm. We work just with families to make sure people are protected. And that's kind of the relationship we're looking at today, where we're looking at parent to a child, but that might be siblings, or indeed when we're looking at our parents as they go into later life. We're based in Brighton, which seems to be the hub of the world today, because we've got Horsham up there, Tracy I know from being fairly local. But with COVID came a lot of breakdown into communication, so now we just do everything on Zoom, so it doesn't really matter where anyone is around the whole country, so we have access to everybody. We do mainly the work around wills, trusts, powers of attorney, court of protection. We don't do horrible criminal stuff, boundary disputes, family disputes, anything like that. We just specialise in this area. We also do lots of outreach work, so that's what today's about empowering people to make choices and put in place the right structures. Just to say, the branding, if anyone clicks on the website in about a month's time, we're changing our branding, having been 12 years now, so it will still see the same name, the branding will just look a little bit different. So we are whisking through why we're here, what we want to achieve, why you must make a will, look at trusts, have a think about decision making and empowering people to make decisions for themselves, powers of attorney, court of protection. Then we're just going to bring it together and look at our family and what our family needs to put in place. And just quickly, if we've got any time today, any time this morning, we'll do questions. If not, like I said, we've got 2 Q&A sessions in a little while. So, this is where I ask someone to be brave enough to tell me something. We, kind of as a family, we know that we've got someone affected with WS, and so we're thinking probably not a great thing to directly inherit them. So not a great thing to give them a direct inheritance. Why might that be? Everyone's had their coffee, and I'm waiting for someone to be brave enough. Benefits, brilliant. Okay, so when you say benefits, what type of benefits might you think about?
I'm not sure, housing benefits.
Yep, what you're actually talking about is means-tested benefits. Yeah. So housing benefit is a means-tested benefit. So if I just put that, they put these boards for someone who's a regular height, and that's clearly not me. So means-tested benefits. The general rule of thumb with means-tested benefits is that we don't want someone to have anything more than a value of £6,000 in their name. If they have more than £6,000, means-tested benefits can start being compromised. So as Louise said, housing benefit, income support, some ESA, some universal credit. But specifically not DLA and PIP. DLA and PIP are based upon mobility and care needs. So they are completely unrelated to means, and you could have millions of pounds and still claim those benefits. Brilliant. Any others? There's sort of 2 others that really interact.
Tax?
No, John, no, but good, no, you're coming on to another slide in a little while. Let me help you out. So, capacity. Capacity has a big influence on what we're doing. So, capacity to manage a big inheritance, whether it be by loss of vision, hearing, those sort of things, capacity can affect us. And the biggest thing is vulnerability. So susceptibility to financial abuse. So by putting something in trust, we're protecting about those 3 core things. And that keeps coming back time and time again in what we do. So a trust is a sort of a tool that we use to put an inheritance in to make sure it's protected. But a lot of people say, don't want to do a trust, it might be too complex, it involves lawyers, they're boring, they don't come out on a Saturday morning to do this kind of thing. Some of us do. So why don't we just give it to someone to look after? That's not great, because what happens if that person gets divorced, is declared bankrupt, dies, and leaves the inheritance off somewhere else? So by actually taking ownership, putting it in a trust, we protect these things, we make sure it's safe. Let's have a think about where our child might live. A lot of people will have the children living at home with them, your relative living at home. If something happens to you tomorrow, where are they going to live? Have you ever thought about it? You probably have, it's probably in your head somewhere, but if you die, it's lost. So actually capturing those thoughts about what that might look like is really important. So sort of some core principles is, looking at trusts, but also thinking about the peripheral issues, which is not just the legal side. So why do we make a will? We make a will because, largely speaking, the intestacy rules simply are not appropriate for us. The intestacy rules dictate what happens to our estate if we die, and it's based on values, and they're not great. If you're married or in a civil partnership, then the value is 270,000. So for me, let's say I'm married to Tracy, and we have one child who's Zach. If I die, Tracy gets the first £270,000 of value of my assets, and half of the remainder, with the other half going straight to Zach when he gets to 18. So they're not great, they're just based on figures. It doesn't matter what assets you've got, it's based on figures. And as I was talking to John earlier, and the prices for property in Brighton are just stupidly ridiculous. It has no correlation. So actually by doing a will, we're taking ownership of what we need to do, which is great, because it's kind of empowering, isn't it? I know a will sounds like it's a scary thing, but it's a really empowering thing because we're making the decisions. We're going to choose guardians, executors, trustees. I'm not going to have enough time this morning to talk about everything in great detail, but guardianship is where we're talking about having someone who's under 18 and needing to appoint someone who takes care, sort of health and social care decisions for that individual. Who is brave enough to tell me what the difference might be between an executor and a trustee? Your daughter would have been brilliant at this because she's going to know some of this. Anyone brave enough to offer up what the difference is between those roles? No one feeling that brave? No? John?
No.
The other slide is coming up in a minute. It's really interesting, isn't it? Because we talk about these in our everyday life, don't we? We often talk about executors, we talk about trustees, and the moment you say to someone, what's the difference? Everyone goes blank. It's really quite simple. An executor is someone who carries out the administration of your estate. So an executor's job is pretty prescribed, usually lasts 6 months to a year. They call in your assets, they pay off your liabilities, they get to the clean assets ready to give to someone or ready to put into trust. So being an executor is actually usually really straightforward and very, very simple. Trustees, you look at the word, what have you got? Trust, EES. So you only ever have trustees when you've created a trust. So in my will, it says, if I die, I give everything to Tracy. No trust, Tracy's my sole executor, job done. My will goes on and says, but if Tracy dies before me, I create a trust and I give everything into that trust to protect it for my son Zach. At that stage, I need trustees. So I need executors all the time to administer my estate, but I only need trustees when I'm talking about trust. Look at the word, it does what it says on the tin. You make a will because you, again, are taking ownership of what your situation is. You're going to make the provision. You're not going to leave it to chance. You're not going to leave it to the government to dictate what happens. There you go, John. You were like 3 minutes too early. Inheritance tax planning is really important these days, and inheritance tax, a few years ago, the government put in place a structure and said, we're going to keep it until 2026. And the purpose of that was because they'd spent so much on COVID, and now it's something new, and they need to reclaim money. So by setting the level of inheritance tax, they're hoping prices will go up, people will die, their estate's going to be worth more, they're going to get more money back. They get something like £6 billion from inheritance tax, and they're really needing to get closer to 10. It's a lot of money they need to start reclaiming. We're not going to talk about inheritance tax today, other than to say, because I'm being filmed, I need to be really careful about what I say, other than to say, if you're a single person and you gear everything up correctly, your inheritance tax exemption when you die can be up to 500,000. And if you're a married couple or a civil partnership, it can be up to £1 million. That's a very general rule of thumb. We can spend hours talking about inheritance tax, but I would have a smaller group than I will today if I said I was doing that. You are empowering, again it keeps coming back, by doing the will you're ensuring your wishes are involved and you are protecting your child, which is the most important thing. That's what you're doing all your life, so why not do it via a will? Trusts. We use trusts a lot in our everyday life. A lot of very wealthy people use trusts for tax planning. We are protecting the person who's vulnerable, as we said when we started. We're going to provide for them but not give them the assets direct. So we're saving that capacity issue, whether it is now or in the future. We're protecting against that, and we're protecting against the means-tested benefit. So you can put as much as you want in the types of trust I'm going to talk about in a little while, millions and millions of pounds, and the individual can still claim means-tested benefits. And that's really important because we want them to be able to still claim, but also still be in the system. Care fees, again, another whole other talk. Care fees are supposed to be capped next year in October 2026. Whether or not it's quite as effective as what the government are leading us to believe at this stage is still to be seen. Every trust pictorially looks exactly the same, and that's super useful when we're thinking about putting a trust in place because we're talking about what we need to fill. And we've got like the 3 trust bubbles. We've got the trustees, the assets, the beneficiary. Trustees are the people who are running the trust. As we said, we only ever have trustees where we've got a trust. Trust, EES, says what it is on the tin. If you've got individuals being trustees, your minimum is 2, your maximum is 4. But quite often you could have professional people, you can have trust corporations, all of those sort of things, and sometimes they act in their own capacity. So we actually today, just while I'm here, we've just launched our own trust corporation, specifically to act in that way for the people that we support. Over on our left-hand side, need to look that way, not this way, we've got the asset bubble. So largely speaking, any assets can be held in a trust. Who feels brave enough to try and offer up an answer to the question, what's the only type of asset that you think might not be able to be held in a trust? It's quite interesting.
Property?
No, we've got property in there. Yeah. Trick question. No? Anybody? Livestock can be held in a trust. Yes, good one though. Yeah, that's not been suggested to me before, but that's a really good one. Anybody else? It's actually really obvious when I tell you what it is. No, shall I tell you? It's an ISA. Yeah, because an ISA is an individual savings account. And because of the sort of income tax benefits you have with an ISA, it can't be held in a trust. But interestingly, livestock can be. You can have a life policy in a trust, you can have a property, you can have stocks and shares, you can have bonds. So it's actually really interesting when we start playing about with what's in a trust, because we can gear up the trust fund to match what the beneficiary's needs are. So like I said, the only sort of thing you can't have is an ISA because of the tax status of an ISA. Over in our beneficiary bubble, we have got who can benefit from the trust. So we can name the individual, or very usefully, we can do things like using descriptors. So descriptors are words that we use that clarify the group of people who can benefit. So we could, for example, say grandchildren, because that's pretty obvious who my grandchildren are going to be, nieces and nephews. We can say every charity registered in England and Wales. It's a very definable group. If I said everyone with brown hair in Brighton, we'd have no idea. But if we have a descriptor that's a definable group, that's really, really useful. And it doesn't matter if there's no one in it right at this moment in time, because we might be saying, well, the trust is going to last for the lifetime of my child. And that might be 80 or 90 years, and we might need to use that sort of projection and these descriptors. So that can be really, really useful. We, as a group of people who are protecting individuals who might fall into any or all of those categories, only really have the choice of 2 trusts. And that makes our life a bit easier because we go straight to those, we don't need to worry about the others. There are loads of types of trusts around, but only 2 that we can use. One is a discretionary trust, and the other one is a disabled person's trust. I'm going to take 2 minutes to tell you what a discretionary trust is, and then explain what a disabled person's trust is. No one's gone to sleep yet as well, so I'm doing really well. So, a discretionary trust is one where assets are advanced or used for the beneficiaries at the choice or discretion of the trustees. So, we've got the same diagram as we said before. We've got the assets, the trustees, the assets, the beneficiaries. The difference in the diagram, other than the letter of wishes, which I'll tell you about in a second, when we look back, here we've only got one beneficiary, and on here we've got 5. We can have as many as we want. So with a discretionary trust, we actually have 3 elements of discretion. The first one is who. So to create a discretionary trust, you have to create a situation where the trustees have a choice of who benefits. And bear with me, because I'll explain why this is important just in a few minutes. So by dumping in a whole load of other people there, we've got the choice. So in my case, I might have my Zach, grandchildren, nieces and nephews, charities. That's absolutely fine. And think about, can you still hear me when I turn around? Yeah? Think about the case that actually, when we're setting this up, we're setting it up for the lifetime of this individual. If this individual dies and there's anything left here, it has to go somewhere. It can only go to whoever's left here. So when we shape up this category here, we're shaping it up to ask ourselves that sort of succession point, that when this person dies, if there's any fund left, where does it go? When in my mind, it goes to any children he has. If he doesn't have any children, maybe it goes to my daughter. If she's not around, to her children. If they're not around, to nieces and nephews. And if there are none, then to a charity. So it's really easy to shape this up when you think about those layers of succession that you need to integrate into that discretionary trust. It does not matter if, on every time the trustees use the assets for this person, they always use it for that person during their lifetime. That's completely fine. They're still using their discretion of who. But they're just always going to say, well, actually, no, none of these are getting it while this person is alive. But the moment this person dies, they exercise their discretion to give it to whoever's in that category down there. So the first element of the discretion is who. The second element is when. So when do we use assets? Well, if this person was in hospital, if they were sectioned and in hospital for a while, we'd say, well, actually, we're exercising discretion not to do anything right at this moment in time. If they come out of hospital, they might need a lot of support and assistance. We're exercising our discretion to kick that back in. So the when is the switching on and off. So the choice, the option, the discretion, switching on and off. And the final thing is what? And I love the livestock thing. I'm going to use that now. I'm going to think about how I can integrate that into my working life. So what assets do they use? You know, we've got a house here. If this person's not living in a great home and there's enough funds here, we can buy a house for them to live in. Completely fine. It doesn't affect anything here. We've already made that very clear. If this person's in a really lovely accommodation, we don't want to upset that. We put it in stocks and shares, livestock, whatever it might be, and we can use those for that person. We can buy them an off-road wheelchair. We can buy them a lovely Toby, the dog who was sitting on my feet earlier on. You know, we can do lovely things like that. So 3 elements to the discretion which are super useful. How does that work for us? Well, anything in a discretionary trust, the legislation says, is protected for means-tested benefits. But if you had a trust that looked like that, it's not. So you have to, and that's why I said we have no choice but to go for these, you have to go for a discretionary trust. You have no choice. Protected here. And as we said at the beginning, anything in these trusts are protected for capacity and vulnerability because it's managed by the trustees. It's not managed by this individual. The funds don't necessarily go into their bank account. Things are bought for them. You're exercising the what and the when to use things and buy things, so it's managed on their behalf. So discretionary trust is brilliant, really brilliant. So it does what we want it to do. Any idea why it is not great? There's a flip side to discretionary trust. There's a dark side. There's always a dark side to everything in the law. You just need to find it. Any idea what it might be? John, you look like you might make a suggestion.
No, I was just wondering if it's around the trustees and how they actually use that discretionary power, but I guess you can just define that within.
Yes, and there is a tiny thing which we can talk about in a bit more detail later, but not just at this moment in time. It's actually, you were closer earlier on, it's tax.
I'll get the question.
Absolutely, I'm going to feed you one and have a little sign saying tax. So the flip side and the downside of a discretionary trust is that historically a lot of wealthy people have used it. And so because of that, the government has shut down the more favourable tax treatment. So very boringly, discretionary trusts are quite heavily taxed. I'm not going to bore you with that today, but income tax largely 45%, capital gains tax at higher rates, and the trust itself could end up paying inheritance tax every 10 years. So it's quite heavily penalised. So what the government did quite a number of years ago, back sort of 1984, is introduce the concept of a disabled person's trust. And a disabled person's trust is kind of an upgrade on a discretionary trust. So a disabled person's trust pictorially looks exactly like this and roughly does everything that we've said about with a discretionary trust. But to have a disabled person's trust, we have a disabled person at that core top level. The definition of disabled person, very roughly, is either having DLA, care component at middle or high rate, or mobility component at the high rate. Or if you're in PIP, it's PIP claiming either of the two components at either of the two rates. So you've got a disabled person core to that. What a disabled person's trust does is wipe out that penalising tax treatment, making it much more favourable, but also it pulls back the trustee's element of their who discretion. And how it does that is it just says very roughly, only up to £3,000 can be given to the whole group of everybody other than the disabled person during the disabled person's lifetime. Once they die, it's fine because you're winding up the trust. So in my mind, a disabled person's trust actually is really useful. It gives us everything we want, but it pulls back on the who, which is great, and also ensures that the tax is a lot more favourable. So, moving on. Mental capacity. So we've sort of had a look at what we're doing as parents, maybe to put in place the inheritance protection, how that's going to work. Let's think about mental capacity and our people who are affected and how we help them. What does mental capacity mean to you? You tell me. Go on, some brave soul. Tell me what mental... Yeah, great.
Like the ability to make decisions and think for yourself.
Yeah, brilliant. So what we've said here is the ability to make decisions and think for yourself. So as people around people who are affected, we want to facilitate that. We want to maximise that and make that happen. You couldn't have given me a better description, that's perfect. Everything in relation to mental capacity is underpinned by the Mental Capacity Act of 2005. That was brought in to bring together lots of disparate law and make sure that we were empowering people. And it introduced 5 core principles which are really super useful for you as families to make sure that individuals can make decisions for themselves, and if they can't, how we go about doing that and how we go about protecting them. So the first one is we start from a positive position. When the Act was going through Parliament as a bill, it started with the name of the Mental Incapacity Act. And some bright spark said, well, that's negative. Saying something is the incapacity is much more negative than the capacity, so they dropped it, and we start now with a presumption of capacity. So when we look at decision making and enabling people to make decisions and choices from themselves, we start from a position of positivity and saying they can do that unless we prove otherwise. So having a diagnosis, we work a lot with the NAS and Down Syndrome Society, having a diagnosis of Down syndrome does not mean to say you can't do anything. Whereas years ago, we might as a society have seen that on paper and said, well, they can't possibly achieve anything. You know, we've got CBBS presenter with Down syndrome, we've got actors, we had some model on the front cover of Vogue. You know, it's incredible. Everything is now about positivity. The next thing is maximising decision making. And how do we go about doing that? Okay, well, who here is better in the morning than the afternoon or evening? I'm a morning person, I get up and go to the gym at 6 o'clock, you get to 5 o'clock, 6 o'clock in the afternoon, I'm not great. Who here let's think about what else. What about time? What about surroundings? Who likes going to the dentist? No, no one at all. So if you went to the dentist, you feel panicky, you feel anxious. If the dentist came to you at home, probably be a little bit easier, wouldn't it? So if we're looking at be a little bit easier. So we're thinking about things that can actually help people. So if we're looking at a big decision and we want to empower people to make a decision, think about the time of day, what's better? Think about the surroundings. Think about communication. You know, we've got a bunch of WS affected people, and communication for them may not be written. Maybe verbal, you know, there may be eye gazes, there may be lots of different things. And just because English may not be their first language, and just because you can't communicate to me in the way that I can communicate, does not mean to say that you don't have capacity. So we have to explore that and maximise and facilitate it. So this is really powerful. This underpins everything we're doing by saying, let's try and enable people to make decisions for themselves. The flip side, though, is that if people can make decisions for themselves, they can make the wrong choice that we don't agree with. Who's been out and said, I'm only going out for a quick hour for one drink with my mates, and 5 hours later and lots of drinks later, you know, things have gone a bit belly up. You know, if you've got capacity, you've got the right to make unwise choices. And that's really difficult. If we're trying to say to people, go out there and do things, and then we want to like pull them back because we don't kind of think they're spending their money on the right thing, we can't do that. You know, people are allowed to make mistakes. We're all a bit maturer, we've been through those mistakes and we've learned from them, we know what we should and shouldn't do. So these are the sort of three positive, if you like, positive elements. And the final two are not negative, they're just things about where people don't have capacity, what do we do? So these three are about people having capacity and how do we enable them and push them forward. The final two, if we're helping people make choices because they cannot make choices for themselves, everything that we do has to be done in their best interests. The best interest is a really important factor that underpins a lot when we're talking about capacity and decision making for people who do not have capacity. It's looking at that individual and saying what is right for them, not what's right for me. So we're looking at their religious beliefs, their social beliefs, and if I'm making a decision for someone, which I do quite a lot in my everyday life, I'm looking at them and putting myself in their shoes. And it may not be that I agree with their religious beliefs or their social beliefs, but it's about them. So best interest is a really important factor when we're helping make decisions for someone who can't make decisions for themselves. And the final thing is, when we're making decisions for someone who can't make decisions for themselves, we have to take the least restrictive option. And that means we need to take the easiest course, the one that enables them to do as much as possible, but just protecting them. So, although not the world's greatest example, an example of the least restrictive option might be someone goes into supported accommodation and because they're vulnerable and can't get out by themselves, you lock the door and they're safe because they're inside, but you take away all of their elements of freedom. That's the most restrictive. The flip side is, the least restrictive is to put in place a carer so they can go out whenever they need to. So, the least restrictive option always has to be the core principle, which is the fifth one here, of how we deal with people who cannot make decisions for themselves. So we then move on to think about when people can make decisions for themselves, and it's, when I see the stuff on the board here about many doctors will never see an affected person, and the limited numbers of people affected with WS and how rare it might be, we need to think very carefully about putting in place that protection structure. And I've seen lots of people affected by WS this morning and can see exactly where their position is. So a lasting power of attorney is a really, really useful tool. And who knows what a lasting power of attorney is? Come on, someone. You must have come across it.
Gives somebody else authority to manage the finances of the person who's being looked after.
Yeah, very close, really close. Yes, so we're now expanding it, that's really great. So a power of attorney is a document where we delegate authority to someone else to make decisions for us. So we as parents need to think about doing that, but what's really powerful, and I keep reinforcing it every time I come back here, I was here about 5 years ago, is that everybody with WS should be putting in place powers of attorney themselves, because they are then choosing who can make decisions for them if there comes a time in their life when they can't make decisions for themselves. It is really super useful. It does cover financial stuff, but it also, as you said, cover health and social care. So they're two separate forms, they look very similar, but they're done separately so that you can choose different people if you want to. We can only do them when we're 18. So once we're 18, if we've got capacity, we can do it. Capacity to make a power of attorney is relatively high, but not so high that it's unachievable. And when you think about what I said earlier about how we maximise capacity, when we're working with young adults, we look at, well, what's the right surroundings for them to be in? You know, do they really want to come to a lawyer's office, or can we do it on Zoom? You know, those sort of things are really useful these days. So they don't have to know what a power of attorney is, because part of the capacity assessment to do a power of attorney is for someone to explain what a power of attorney is, and then get them eventually to sort of relay it back. So the way I deal with it is to say that this is what a power of attorney is, Louise, and I'm going to tell you about a power of attorney, blah, blah, blah. Then I'm going to probably change the subject and say, oh, what do you like doing in your free time? Get your mind to go elsewhere, then come back and say, can you tell me what a power of attorney is? So have you the knowledge and information to retain it and then read it back to me. But also to think about who you're choosing and the pros and cons of that. So I had a case which involved a young lady with Down syndrome, and when I talked to her about doing the power of attorney, she said, I want mum but not dad. And I said, oh, okay, well, that's really interesting, because I know you folks, I've dealt with them for some time. I said, why don't you want your dad? And she said, because when he finishes work on a Friday, I think he'll go off to the pub with his mates and use my money to buy a beer. And the great thing about that was she demonstrated to me that she understood that by giving a power of attorney, Dad had access to her bank account. She had a misconception. Clearly Dad went to the pub every Friday. She had a completely misconcept of the fact what her dad would do, so we just explored that and sort of ironed it out. But by saying that, she showed me and demonstrated to me she was aware of the risk, which was exactly brilliant. So capacity was, she just ticked the box, not a problem at all. So from my point of view, this is one of the things that I can't reinforce enough, which I think is really super, super important for your group, is that your young adults from the age of 18 need to get in place powers of attorney as soon as they possibly can. There are mini insurance policies. So if you don't need them, that's fine, they're just in your back pocket, you don't need to call on them. But if you lose capacity, they are really important because they're there and enable people to make decisions for you. They're quick, they're relatively cheap, they're relatively easy to do. The flip side is, if you lose capacity and you haven't given a power of attorney, then if someone needs to make decisions for you, there is no option other than to go to the Court of Protection. And that is a right nightmare because it's expensive, it's time consuming, it's an ongoing headache. Anybody had any contact with the Court of Protection? No? Over COVID, they've also gone back by about 3 months in terms of their timescales. They've lost things. They're in a bit of a mess at this moment in time, and I'm saying this on camera, which I must remember not to say things that I regret later on. They also do a great job. By their own admission, they are in a little bit of a mess. So why might we need to go to the court? We might need to go to the court if someone has lost capacity and they haven't put in place powers of attorney. So again, the importance of doing a power of attorney is really clear. So if someone's lost capacity and we now need to take decisions for them, we can't automatically do it unless the court gives us that authority. So the court fee, just to give you an example, the court fee is £371. The registration fee for a power of attorney is £82. Yeah, massively different, just even on the fee that you're talking about, let alone the time scale. In the same way as a power of attorney, they're split between financial, health and social care, so you can do either or both at the same time. They each come with their own level of complexity and whether you need it or not. I've said here, be careful to apply at the right time because it's really important to think about the time scale attached to it. Roughly speaking, if you need a general deputy order, so a deputy is someone who steps into the shoes like the attorney we talked about earlier. If you need a regular deputy order, timescale these days, roughly about 8 months. So people come to us in crisis and say, I need this now. And I'm like, well, what's your crisis? Because unless it's a life-limiting decision, you can't get an emergency order from the court, really, generally speaking. So think about it really carefully. So I'm just winding up, and I have been under strict instructions from Tracy not to go over, and I'm pleased to say that I'm not going to go over because I know exactly where I am on my slides. So our family, our typical WS family. I got mum and dad with WS child, adult, young adult, 19. What should they do? Well, based on what we've talked about, they need to do a will. That's clear. They need to not leave it to chance. They need to actually make that empowering decision, which is really great. You know, think about a will as a very empowering document that you're putting in place because you're making sure you put in place that structure. They need to think about that trust because we've got all of these elements that we start with at 10:35. The trust is the receptacle that takes the inheritance, that protects everything. It's really great. It's such a useful tool. Powers of attorney. Can't keep reinforcing it enough. It's so important. Maybe next time I come, I'll have a little power of attorney factory in a corner somewhere where we just, we can just bang them all out. Because they are relatively straightforward to do, but they're so important, so important. The flip side is, if you haven't got it and you need to make decisions for someone post 18, then the court of protection, is where we're sort of looking. So I'm doing 2 sessions. I think my timing might have shifted a tiny bit, but roughly the same. So I've got 2 sessions. They're Q&A sessions. Originally we thought about splitting them into a will and trust session and then the decision-making court of protection powers of attorney because they sit separately. What I think I'm going to do, because I had a brief chat to Tracy this morning, is probably just open them all up because I think people are going to swap around. So we're not going to have a huge amount of time now to take any questions, but if they don't fit in now, I've got 3 minutes or so left. I've got big Q&A sessions later on. So, any Q&As? Because we're filming the Q&As later as well, so if there aren't any now and you desperately need to go for a break, that is completely fine and we can take Q&As later. But any now while I'm here? No? Great, okay, well no one went to sleep, which is clearly a benefit of being in this slot and not one a bit after lunch. But thank you, I'm around for most of the day. I think I'm not leaving until